The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 942. Coming to you on Monday, the 1st of July, 2019. On this program, I will speak to you on the topic malicious prosecution. But before getting into the topic, a few brief preliminary comments. Firstly, and as usual, my condolences go out to all families which have suffered recent bereavements. Secondly, I would like to remind spiritual Baptists that this coming Sunday, the 7th of July, we will be having the installation of cannons at St. Mary's Cathedral, Overland, beginning at 1 o'clock in the afternoon. And thirdly, I would like to send happy birthday greetings to my wife, Bishop Juliet Campbell, who will be celebrating tomorrow. I would also like to send greetings to my sister Claire in the United States of America. She also will be celebrating tomorrow. And of course, I would be celebrating towards the end of the week. Into the topic now, malicious prosecution. The word prosecution should be well understood to everybody. That is, when a person is prosecuted, when a charge is brought against a person in the court of law. And malicious means with malice. Now, strictly speaking, a complaint of malicious prosecution may be brought in respect of a civil matter. But I want to confine the meaning and the application of the term for the purposes of this program to criminal matters. That is, when someone by malice brings a false charge against you, and the police take criminal proceedings. Now, there are 4 ingredients of criminal prosecution. First, there must be a prosecution, that is, a charge must be brought. Secondly, the charge must result in your acquittal. Because if a charge is brought against you, no matter how malicious, and you are convicted, then you cannot complain about malicious prosecution. Somebody may have made a complaint to the police against you for spite, but the complaint may be true in substance. The police may arrest you, have your charge brought before the magistrate, and you may be found guilty. Then you cannot sue the person who initiated the proceedings for malicious prosecution. The third ingredient of malicious prosecution is that it must have been brought without reasonable cause. And the fourth ingredient is that it must be brought with malice. Occasionally, persons have quarrels with other persons, and in order to spite the person against whom you have a quarrel, you make up something against them and go to the police with an entirely false accusation against the person. The police have a duty to investigate every complaint made to them. They cannot just file a complaint because you show up at the police station. The police have to carry out their own inquiries. If they're not satisfied, they may say, look, go to a lawyer and let him bring a private complaint on your behalf. So let us say you make up a false case against somebody. You go to the police and give the police a lot of lies against the person. The police carry out slipshod investigation, and they feel that you have a case because you may be able to produce one or two witnesses to back up your story. The correct word for backing up is to corroborate your story. And therefore the police may file a complaint against you, have you arrested and charged, you get bail, and you go before the magistrate on the appointed day. And then it turns out that the evidence against you was entirely fabricated, made up lies. You are acquitted because the person who made the complaint to the police did so without having any good, solid reason to do that other than enmity and spite. And the person was motivated by malice. They were malicious. At the end of those proceedings, you can go to a lawyer and file an action against the person who had initiated the proceedings or who had gone to the police with your name falsely in the first place. And your lawyer on your behalf could bring an action against that person seeking compensation for you, called damages. And if you bring such an action, it is enough for you to prove either that your character was damaged by the charge brought against you, or you incurred expenses in having had to defend yourself. You may have hired a lawyer to go to court for you to face the false charges. You may have been kept in the police custody overnight or for over a weekend. Therefore, you would have suffered the indignity of imprisonment for even a night. For all of those things, you would be entitled to compensation if the person had you prosecuted maliciously. Now, it isn't enough for someone to have a suspicion against you. For example, if your house is broken into, you may suspect that so-and-so was the one who broke your house. But until you have some sort of evidence, you can go to the police and say, look, my house is broken into and I suspect Tom Jones broke into my house. Even if you tell the police that, they are supposed to investigate. And until the police find some kind of evidence to show that Tom Jones was the person who broke your house, they should not file a charge against Tom Jones, have him arrested and charged and taken to court, if they have no evidence linking him with the breaking of your house. In the courts of law, suspicion is not evidence. You can't go to court and tell the magistrate, oh, you had a good mind, that feeling that it was so-and-so, it was Tom Jones who broke your house or did something to you. Or you had a dream that Tom Jones was the one who broke your house, and you come to court depending on your dream as evidence of Tom Jones' involvement in the breaking of your house. You have to have some hard evidence linking Tom Jones with the breaking. What if you have no evidence? The police investigate, the police find no evidence against you and still bring a charge against you. Well then, when you are acquitted, as indeed you will have to be acquitted, there being no evidence against you, you can bring a charge against both the person who initiated the complaint and against the police for acting on a complaint without having any evidence at all linking you to the offense. Therefore, when you notice that you make a complaint to the police about something that happened to you, and time passes, you don't hear anything from the police. A week passes, 2 weeks pass, 3 weeks pass, 4 weeks pass, you haven't heard anything. Go back to the station and find out what is happening. Remember, the police have a lot of work to do. They have a lot of other people to look after, a lot of other complaints other than yours to investigate. So you cannot expect the police to drop everything they are doing and attend to your complaint. Therefore, these things take time and you have to be patient. Now, it's another story if you make a complaint to the police and months go by and you don't hear anything from the police. You give them the name or names of people you have reason to believe were involved. And as far as you know, the police have not gone to interview the persons, have not done anything to investigate your complaint, then you have a right to go to the station and find out what is going on. And let me warn you, when you go to the police in those circumstances, following a complaint you made some time ago, don't go with any hostility and haughtiness and give the police a rough time before you find out what is happening. I've known cases where somebody has missed something, presumed stolen. They go to the police station, they make a report. Some time passes, not a long time, but a couple of weeks, 3 weeks pass, and they hear nothing. Instead of going to the station politely and mannerly to find out what is going on, you go there cussing the police. So long I come here and make a complaint, no, I don't do nothing, and carrying on. In those circumstances, the police will have a right to turn you out of the station and tell you, look, you can't behave in this unmannerly manner. Get out of the station. The police are human too. You can't go and cheek off the police without finding out what is going on. The person who was in charge of investigating your case may have gone on leave, or have traveled, or they might have been sick and off duty. There could be any number of reasons why the police take time to investigate your complaint. But assuming the police do investigate your complaint, and they may have a smattering of evidence against the person, but the evidence may be weak, and you keep harassing the police and say you want to make a case, you want the person charged, and in frustration, police get annoyed and say, all right, and bring a charge against the person. And when the matter goes before the magistrate throws the case out for lack of credible evidence. The person can sue you for malicious prosecution. And you can't, when you are sued, you can't mount a defense, well, I didn't prosecute you, the police prosecuted you. That doesn't. You caused the police to launch a prosecution. Therefore, you would be liable for the prosecution, even though you were not one who actually wrote up the charges and served them on the person. You caused the prosecution to be brought. And if you do that maliciously, you had no good reason except that you're spiteful and you have something against the person from some previous encounter both of you had. You can be sued for malicious prosecution and have to pay plenty money if the judge or the magistrate finds that you are guilty of causing a prosecution to be brought in cases where you had no probable cause and where you were motivated by malice. Now, it isn't in every case that somebody is acquitted that they can bring an action for malicious prosecution against the virtual complainant. And when you read in the newspapers about virtual complainant, or you hear on radio and television, virtual complainant, it means the person who made the complaint against you and caused you to be arrested and charged. Virtual because they are the ones behind the scenes who initiated the process. Complainant because the complaint is usually made in the name of the Commissioner of Police. So when the case is called up in the magistrate's court, it would be the Commissioner of Police against so-and-so for wounding. Commissioner of Police personally has nothing to do with the matter. But prosecutions in the magistrate's court, and I'm not speaking about prosecutions that go on to the High Court as indictable offenses. I'm talking mainly of summary offenses. Prosecutions are brought in the name of the Commissioner of Police. If the matter is an indictable matter, and the magistrate, having heard evidence on the preliminary investigation, decides to send it to the criminal assizes for trial before judge and the jury, then it is the Queen against so-and-so. Of course, the Queen is in England, has nothing to do with these matters, but the Queen represents the Crown, and it's the Crown who is the complainant in the case on behalf of somebody who is the victim and who initiated the proceedings. So that the organs of state, the coercive organs of state, that is the organs of state which are legally and constitutionally entitled to bring coercion against you, force against you, compulsion against you. Those organs are there for the protection of citizens and for the upholding of their rights. But those organs are not there to be abused. And whenever you make a false report against somebody, you are abusing the coercive arm of the state. And for that falsehood, you are liable to get yourself in trouble because you could be sued for malicious prosecution. And if indeed you cause the police wrongfully to arrest somebody, you could be sued as well for false imprisonment. If the police on their own arrest somebody without having any credible cause, in other words, without having a good reason to do so, the police can be sued for false arrest, wrongful arrest and false imprisonment. So that while the organs of state are there to help you, they're not there for you to abuse, and so to victimize other people and to cause other people loss of time, loss of reputation. Because, you know, suppose a parent makes a false complaint against a man for interfering with their underage daughter, and they do it without having any good reason except that they want to spite the boy or the man. The matter goes before the police. The parents force the daughter to give a false statement to the police that how she was molested by this man, and so on and so on. And the police go and dung hands on the fellow and lock him up and charge him. If he goes to, and he is, when the case is called up, nothing comes of it. His name is already in the newspapers, on social media, how so-and-so calling his name was arrested and charged for molesting this girl, which and while the man might be totally innocent. And when the case is heard, the man is acquitted, no evidence against him, he can turn around and sue for false prosecution, for malicious prosecution, because his name has already gone all about to say that he was arrested and charged for molesting the girl. And people who don't know the story, they will say, oh, and they read that, and you know, a lot of people like to believe what they read without having any evidence as to whether it is true or not. And social media likes to take it up, its name on Facebook all over the place. Sometimes even his photograph is all over the place on Facebook, in the newspapers. And when you hear the bounce, nothing comes of the case because the poor man is totally innocent. He can turn around and put a lawyer on whoever caused that, the girl and her parents. And if she's underage, the parents have to take responsibility, because they will sue the parents for what their daughter has done. And some people, just out of spite, implicate other innocent people in crimes and have a great publicity, because more people will hear if you are charged falsely for a criminal offense. Most people will hear about the fact that you are charged. If you are acquitted, not all the persons who heard about the charge will hear that you were acquitted. Indeed, they may even hear you were acquitted, but don't care. They still have it to say that you did so and so. But you must be had a good lawyer and you get off. So people still believe that you are guilty of the offense even when you are acquitted. And that is why in cases like that, when you bring an action for malicious prosecution and you succeed, the guilty parties have to pay a lot of money, because the damage that they would have done to your reputation cannot be repaired. You think you could go around and tell people, well, look, hold up a placard, I was found innocent by the court. Half the people wouldn't believe that you were innocent. They would say, he was really guilty, but he got off, he lucky. Excuse me. So that if you are going to make a complaint that somebody is guilty of criminal conduct, make sure you have good grounds to make that complaint. Make sure you have the evidence tending to show that the person did what you alleged he did. Now, there are other cases where somebody actually does something against you criminally. You have witnesses, and you go to the police, and the police takes statements from the witnesses and so on. Person is charged, brought before the court. When the case is called up, you look around, you can't find any of the witnesses for various reasons. Some witnesses may be threatened. So look, if you only go to court and give evidence against me here, you know what I will do you? And then because the witnesses are terrified, they may be afraid to go to court when the time comes. And you may lose the case. The person may be acquitted for lack of evidence. Now, that person, if he turns out to be a person who is going to sue you, and you can show that you had good evidence, that is, you can show at the civil proceedings that you really had a good case against him, but your witnesses, for whatever reason or other, did not show up, you would be allowed to show to the judge the statements the witnesses gave to the police. Then when the judge hears the complaint of malicious prosecution, the judge will say, yes, I agree you had reasonable cause to bring this prosecution, so I'm not going to find you liable for malicious prosecution because you had good reason, just that your witnesses let you down by not showing up and so on. So what I'm saying is that there are cases where you start with a good case, but somewhere along the line, things unravel and the person you accuse gets off. It doesn't automatically mean they can sue you for malicious prosecution. Because when they sue you, they have to show that you had no good reason to bring them before the court after all. But once you can satisfy the civil judge that you had good reasons and you were not motivated by malice, then you will defeat a claim for malicious prosecution. The moral of all of that is that we must use the law and the organs of state, the police and the courts, in an honest, straightforward manner out of integrity. And we must not seek to abuse those institutions just because we are spiteful against someone. All right? All right, that is all from this program of The Law and You. Next week will be Carnival, so there will be no program next week. I look forward to being of further service to you the following Monday, Divi, in this public service nation building series, The Law and You. Do have a peaceful carnival season. Don't get into trouble. Enjoy yourself with restraint. And may the good Lord continue to bless all of us.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.